Welcome to the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real-world impact with insights from top researchers, practitioners, and officials. And today, we have the immense pleasure to have with us Victor Fernandes, Commissioner at CADE, the Brazilian Competition Authority. And throughout his career, he has served in a number of different positions at public authorities, providing his expertise in regulation, including in his current role at the Brazilian Telecoms Authority or at the Federal Supreme Court. And he also manages within all of these activities to make some time to teach, and also holds a position as a lecturer of economic law at IDP in Brasilia. So welcome to the Agora, Victor.
Thank you very much. But I'm very happy to be here for two reasons. First, because I'm following with great interest the Binary Agora, and second, because I'm a great fan of your work. So it's a pleasure to finally meet you and to have this conversation with you.
Thank you, Victor. And the admiration goes both ways, actually. On the 17th of September, the federal government of Brazil sent a bill to the Chamber of Deputies amending its competition law to supplement with an asymmetric regime applicable to economic agents of systemic relevance in digital markets. I don't know if you have come up with an actual official translation in English yet. And if the amendment is finally passed into law, it will basically allow CADE, so the Brazilian Competition Authority, to both designate these economic operators and also impose obligations on them depending on their economic characteristics and the configuration of their business models. To start off the conversation, Victor, I wanted to ask you about the distance between this amendment and the competition law regime, and whether these two regimes will apply in parallel, they will be complementary, and whether the procedural and the substantial safeguards will cross-cut both of them.
Just taking a few steps back, I think it's important to highlight that in 2022, we had a first proposal of digital regulation for Brazil. This first proposal, which is the bill 2768, was pretty much inspired by the DMA. This first proposal was not subject to a huge scrutiny in the antitrust community in Brazil, I would say. Because of that, proposal did not advance so much since then. Meanwhile, in 2024, the Brazilian government opened a public consultation about this topic. This was a very, very inclusive public consultation, gathering inputs from academia, from civil society, from companies. And also CADE has submitted a very important contribution for that public consultation. Based on that new inputs, the Brazilian government has adopted this new proposal. As you said, this new proposal adopts the form of amendment in the current competition law framework. It would be very, very close in terms of model to what has occurred in Germany with Section 90A. It's not an autonomous legislation. I think that the whole idea is that we will have two parallel regimes. The first would be the competition law procedures as we know it, that are already based on Article 36 of our competition law framework. And for new economic agents, with, as you said, with relevant and systemic position in digital markets, there's going to be a new form of procedure, a new form of regulation. As we have seen in Europe as well, there are going to be questions about what are the spillovers between these two parallel regimes. So whether or not we're going to see some principles from the more traditional antitrust framework being applicable or not, those are questions that we'll definitely raise in the upcoming years.
Going to the main objectives of the amendment, so these new proceedings and the new type of digital, in inverted commas, regulation seek to attain three different objectives: to reduce barriers to entry, to protect the competitive process, and also to promote freedom of choice in digital markets. How would you expect those objectives to impact the enforcement of these rules by CADE?
That's a very, very important question. And I would say that Section 47B of the new amendment is the most relevant one, because that's the section which outlines the three goals that you have mentioned. I think here we have a huge departure from the traditional competitional framework in Brazil. Our legislation was mainly, its core principles were designed in a legislation that comes from the 90s. And back then, the legislation says that conduct that were adopted by as efficient competitors shall not constitute an infringement under the Brazilian competition law framework. This provision still exists. It is in Article 36, the paragraph 1 of our current legislation. And when we see this new proposal of Article 47B, I think there is a huge difference here when we talk about competition as a process, when we talk about freedom of choice, and when we talk about reduction of barriers to entry. And I think that most of those goals are somehow related to what under the DMA, for instance, we understand as contestability. Is the idea that those regulatory obligations should be imposed in order to guarantee that the newcomers, the new players could impose some competitive constraints against the incumbents. If we think in comparison with the DMA, maybe a relevant question that might rise is, and what about fairness? It's very interesting to ask because the title of this new bill, as it was proposed by the Brazilian government, is the new legislation of fair competition in digital markets. Nevertheless, we don't see the word fair or fairness in the principles. That might prompt a question about whether or not fairness is a principle or is a goal to be considered in the design of these obligations. And I think that's a very relevant question that is gonna be posed during the implementation of this new regime. But as I see so far, I think that the main worries here are to address concerns around contestability of digital markets, and that's why reduction of barriers to enter may be the first in the list of the three goals under Article 47B.
Within the few remarks of the bill as it was sent to Congress, there's a clear maybe prompting, despite of all of these differences that we have been outlining with regards to the DMA, that the regime has really been greatly and mainly inspired by the German, as you said, also the Japanese and the British efforts in regulating these digital markets, but not the European DMA. In that sense, designation of these economic agents of systemic relevance in digital markets will be made for 10 years, as I understand, and they will touch upon the whole economic group. The law gets passed in its current form. Can we expect that when the operator is designated, all of the services run by that same operator can fall within the scope of the amendment? So all of the services that that particular economic agent provides to the market?
As I said before, last year in 2024, there was this huge public consultation led by the Ministry of Finance of Brazil. And after the inputs was gathered, the Ministry of Finance released a very interesting report setting out the principles that should guide the new legislation. In this report, Minister of Finance has explicitly said that we should not adopt a DMA-like proposal, but rather a legislation more similar to the UK or to the German or to the Japanese model of legislation. There was an intention behind that. It has to do with some perception that maybe CADE faces some capacity constraints and we do not have a huge agency like the European Commission. And because of that, maybe a more linear regime would be more adequate for us. Based on that, what I see in the proposal, as you said, is that we have a huge list of obligations, of do's and don'ts, just like the DMA. But here, the main difference is that these lists of obligations, which are the obligations that the gatekeepers should follow, those are not self-applicable obligations. Those are just examples. And those are outlined in Article 47A of the proposal. But those obligations would only be enforceable as CADE defines a code of conduct for these firms. And because of that design of the regime, it's is not so clear about what's going to be the scope of the firms that should be regulated. As those obligations will be outlined in a code of conduct, I think that CADE will make it clear when drafting the code of conduct for each company, what are the services from each one of the gatekeepers that should be considered a target for the regulation itself. But there is a question that is very, very relevant, because I think that CADE will take this in consideration in the design of the code of conduct itself, which might be different for each one of the gatekeepers, and the timing of designing this code of conduct will also be relevant in that regard.
If I'm understanding what you're saying, once the amendment comes into force and it's applicable to these economic agents, then the competition authority will draw out some codes of conduct similar to maybe what the CMA is currently doing with Google and Apple, in the sense of, okay, we are outlining what markets and what problems we are most worried about. I believe that the amendment also talks about the need for an economic justification to activate the need for regulation. Those codes of conduct would be established individually for each of the economic agents, and those would define the scope of the amendment and their application, right?
That's perfect. That's the whole idea. That is why it's some kind of a mixture between the German model and the UK model, because we will have this code of conduct defined by each one of the gatekeepers, and then there's going to be more clear what is the scope of the regulation for each one of them.
The bill also stresses that within CADE, a new unit will be dedicated and created by the amendment to address these digital problems and digital markets, and it will then propose to the tribunals a sort of council within CADE that takes the decisions, and also the impositions of the obligations on these economic agents of systemic relevance, as opposed to other regulatory configurations such as the TMA. The main focus of the bill is also to target anti-competitive conduct also in a faster way than the antitrust regime, because that's the whole point, right? For instance, obligations on, as I said, on the designated operators must be supported by these economic justifications of the codes of conduct. I was wondering, how will this new unit manage to accelerate the pace of the former proceedings that CADE performed on digital markets via antitrust, whilst also preserving the necessary economic and legal rigor that we need involved within the competition policy framework?
That's the huge challenge that we will face, because today we have a very interesting institutional model at CADE, where the general superintendent makes the whole instruction of the cases, and then it makes a kind of statement of objection in the conduct investigations, and then send it to the CADE's tribunal for ruling. In the new regime, we are going to have a second superintendence, which is going to be focused on digital markets, but there's going to be some division between the work that is going to be done by these two general superintendents, because the first will still be responsible for antitrust procedures even against large digital platforms. As we talk about in the first question, there's going to run two parallel regimes, and the first regime, the more traditional regime, will still be under the umbrella of the general superintendents. So this new general superintendents for digital markets will only be responsible for defining the obligations under the new regime.
This is a really systematic and comprehensive approach towards the digital markets, especially because of this exemplar list. Maybe there's also some preoccupation, and as the legislative process also progresses within the Brazilian Congress, we are maybe seeing that those obligations are transformed not only from the exemplary list to a set of obligations that some economic agent must comply with. So I was wondering whether you had anything more to add on blind spots that we have made that we may have missed on the bill?
Theoretically, anything can happen in Congress, as you said, because of course the Brazilian Congress can change the legislation in several aspects that we cannot foresee. In general, this model of legislation is very, very fit for the purpose of enhancing competition in digital markets in Brazil. And as I said before, this was a proposal that was product of very intense discussions between the government, CADE, and academic society as a whole. I think that the core of the regulatory model here, which is the idea that there is a list of non-exhaustive obligations, actually has a lot to do with CADE very successful experience in reaching commitments and agreements under Brazilian competition law framework. We have very interesting cases involving digital platforms, large digital regional platforms in Brazil, just like iFood, just like Gympass. Those are very interesting cases and are very specific to the Brazilian reality. And all those cases were solved by commitments that were negotiated between the firms and CADE. And we have gathered a very interesting experience in doing that. And I think that this regulatory model that is at the table right now prompts a room for us to get this experience and leverage it to the digital markets. So that is why I think this proposal is very, very fit for the purpose here. And we hope that a proposal go unmodified by the National Congress, but of course, we know that they can change everything, and they will do that by discussing with society as it should occur in a democratic society as we have in Brazil.
You were one of the figures in really introducing the concept of ecosystems and digital ecosystems within enforcement on antitrust and in digital markets. I was wondering how you think that the amendment would interplay.
As you said, over the last years, CADE has been handling very interesting investigations in digital markets. Some of them have parallels with the investigations that you have seen in Europe or in the United States. We had more recently this Apple case, which was discussed by CADE's tribunal. I think the most difficult part for any competition authority around the world is how to design remedies. That is the question that we have raised in every one of these cases so far. As I said before, most of those cases were addressed by commitments. And when we do commitments, I think that in some regard, we are doing somehow a form of regulation. I guess that the new competition regime would be very, very useful for us to design these obligations for gatekeepers in digital ecosystems in a more clear way. Even for the firms, this legislation is also very, very useful. CADE will adopt a code of conduct based on this non-exhaustive list. But this non-exhaustive list already represents some guidance for the gatekeepers to adopt some norms of governance under their digital ecosystems. The bottom line of that is that I think that this new legislation provides more clarity and more understanding about what are the measures that CADE should or could adopt for enhancing competition in digital ecosystems.
Thank you so much, Victor, for all of your insights and also for accepting the invitation to participate in the Agora on such short notice.
I just would like to thank you very much for this opportunity. As I said in the beginning, I'm a great fan of your work, Alba, and I've been following the binary Agora over the last months, and you are providing very, very insightful material for those ones who are discussing these topics around the world. Thank you very much.